Hello, welcome to our next lecture. I am your instructor, Cole Watson. This week we are covering Marbury v. Madison, a very important case, one of the first cases that we have from the Supreme Court, and we're going to look at a concept called judicial review. So we're going to get a little bit of the background here first. Let me see if I can figure out my presentation here. There we go. So, Supreme Court background, right? We talked about jurisdiction. We've talked about how courts are set up. They look at the big picture with regard to how two disputes come before the court and ultimately have to resolve that dispute, to resolve that dilemma, whatever it may actually be. So, within the Constitution, right, you should have already read the Article 3 that establishes the one Supreme Court. So within the Constitution, that is where we are going to park our conversation for today. So Article 3, Section 1 of the United States Constitution. The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both as the supreme and inferior courts, shall hold their offices during good behavior, and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. Fantastic, right? One paragraph. That's what it looks like in my book. I don't know if I can figure out a way to flip around the mirror version of this camera view. But anyway, super important concept, right? All of a sudden, we're coming from the common law, right? We've talked about the history, how courts were set up, how judges were instated to handle disputes, right? Handle problems that people have, right? People live together, they give up certain rights, rights are infringed, and so we have to start figuring out as a society, as a civil and just society, how are we going to resolve these sort of disputes? So the framers of the Constitution thought to themselves, you know what? A Supreme Court with inferior courts would be a great way to approach. Excuse me, let me exit out of this. Okay, I think I'm back. Would be a great way to set up a hierarchy, right? So we have the United States. It's founded, the Constitution is put together, and now the framers are starting to think about, well, wow, okay, we're going to have a lot of different people in different states now with different issues. If you've studied any of that sort of United States history, what are we going to do about managing our people? So the Constitution comes in, right? It establishes how the government's going to be set up, but Article 3 in particular is going to point to one Supreme Court, okay? The adjective there and noun, when you see those combinations in law, they become very important. They become what's called terms of art. We've, I think, touched on that a little bit, but let's park there for a little bit. So one Supreme Court would just kind of naturally imply that that's the final say on all matters. So if there's disputes coming from the inferior courts, then eventually they get up to the Supreme Court, and that's going to be the final say on whatever that dispute may be. Now, when we think about it a little bit further, how is the Supreme Court vested with power, right? What sort of powers are they given? Here's the Constitution, again, that establishes the court, but what sort of matters, perhaps, or cases, or sort of jurisdiction do they have over a variety of cases? So that's Section 2. I won't read that in whole. You should have already looked at that too and read through it. But Section 2 is going to become very important here in the case that we're studying for this week, Marbury v. Madison. So it's suffice it to say now that we can delineate between appellate jurisdiction and original jurisdiction. Section 2 of Article 3 of the Constitution is basically going to outline those two different types of jurisdiction. But for our purposes here, original jurisdiction means that the Supreme Court can, in fact, hear cases without going through inferior courts. For example, sometimes states will dispute about certain matters. I'm in Texas here, so let's say that Texas and Oklahoma all of a sudden started fighting about where their border was to be drawn in the Red River. Well, is it here? Is it there? That is actually a contentious issue, not necessarily with Texas and Oklahoma in particular, but when water is a boundary, that does create a lot of issues, right? Water moves, ingress, egress. But for our purposes, if states start fighting, if they have a dispute, then yeah, it kind of makes sense that rather than try a case in Texas or try a case in Oklahoma, there's going to be a federal answer to that dilemma. Original jurisdiction. It can originate. A case can originate within the Supreme Court. Now, appellate jurisdiction is more times than not what kind of cases the Supreme Court is going to hear. Appellate implies appeals from a inferior court, a lower court. So, for example, the Dobbs case, Dobbs v. Jackson's Women's Health Organization, was handed down last year, which basically overturned Roe v. Wade. If you are curious about that case at all, I think I have a lecture that's published somewhere out there, maybe on YouTube, that you can go and watch. I designed it for Christian educators, but if you are curious, then please go and look into that and let me know if you have any questions about the holdings and the analysis and things of that nature. But for that case in particular, it started out in the Federal District Court of Mississippi. So Mississippi has a variety of districts, I believe. I wish I actually knew that off the top of my head. Texas is easy to pick on. There's 4 federal districts, north, south, east, and west. And so within those districts, there's particular courts that are a part of the district. So cases can originate there depending on the procedural aspects of the case, whether there's standing, which we'll talk on, I believe, in next case. But for our purposes here, the Dobbs case started out as a lawsuit in the Federal District Court in Mississippi. Now, what happened was that it eventually went up to the circuit, the Fifth Circuit. There's a variety of inferior courts that the Constitution allows for. Those would include the circuit-level courts. So if you've heard of the First Circuit or the Fifth Circuit or the Ninth Circuit, those are all the intermediary courts. Still very prestigious. Their word is, in fact, law. But it's from those courts typically that cases are appealed up to the Supreme Court. So, for our purposes, that's what we consider appellate jurisdiction. There's going to be an issue that starts out as a dilemma, right? 2 sides, X versus Y, right? Dobbs versus Jackson's Women's Health Organization, Roe v. Wade, Marbury v. Madison, and starts working its way up the court hierarchy. So district court, and then to the circuit court, and then to the Supreme Court. So all that to say is that to actually get a case to the Supreme Court is fairly impressive. They don't take every case. I looked up some stats here. It's about 1 to 2% of cases each year that the Supreme Court could consider are actually considered. So in other words, just because there may be a very important dispute perhaps that has made its way up the circuits up through the inferior courts does not necessarily mean the Supreme Court is going to listen to it. It's not going to necessarily listen to those arguments and accept the case and have the attorneys then give their oral arguments, have all sorts of interested parties submit briefs for both sides, arguing for one side or another. But all that to say, though, is more times than not, the Supreme Court is going to take cases based on their appellate jurisdiction. That's going to become very important in this case, which you may have already seen and been able to tease out there on the last part of the case. But for our purposes here, very important, original jurisdiction. The case can, in fact, originate in the Supreme Court. Appellate jurisdiction has to actually go through a variety of levels. It has to go up through the inferior courts. Okay, talked about procedure. Procedure involves a certain ordering of things that has to take place for the court to even hear the case. Standing, for example, the court has to have jurisdiction, and you as a grieved party have to have standing to present that case before the Supreme Court. We'll touch on that throughout the semester as it goes on. Civil procedure and criminal procedure are very important classes you'll take in law school. If you decide to go there, it is an academic exercise. It is not for the faint of heart. It involves an incredible level of detail and intellectual maneuvering, but it is a fascinating study. So we'll touch on aspects of procedure throughout this course, but for our purposes now, we can keep moving on. Switched over on you. Okay, there we go. A little technical difficulty there. Okay, so like I said, we're going to talk about judicial review. It's the concept basically that the court, the Supreme Court, or any of those inferior courts can look at a given dispute and determine whether that dispute is constitutional. Or sorry, one of the resolutions would be constitutional, whether it pertains to the Constitution. So I think, and I'm not really sure how to gauge this exactly, but the concept that there could be things that are unconstitutional is perhaps taken for granted, right? We kind of have that in our society at this point. We know generally what the Constitution is, but when it comes to a matter of determining whether it complies or comports with the Constitution, that is not exactly baked into the Constitution. So this question, where does this Constitution provide that the Supreme Court can review and determine the constitutionality of a given legislative or executive act? That's kind of the question we're going to start wrestling with here in this case. Like we talked about, there is the establishment of the Supreme Court. That's Article 3, Section 1. There is original and appellate jurisdiction, which gives the Supreme Court certain powers over a variety of cases that are named in Section 2. But the concept of constitutionality, right, the concept that the Constitution provides for certain requirements, parameters, procedures, things of that nature, and somehow that could run afoul, or excuse me, a legislative act could run afoul of the Constitution, right, and violate the Constitution. That's not in the Constitution, right? It's not in a provision. So that's kind of the question we're going to start asking right now is, well, where did it come from, right? If we know that courts now, and again, largely taken for granted perhaps, if we know that courts now can look at a given dispute, like whether the commission has to be delivered to Mr. Marbury, whether that is the under the jurisdiction of the Supreme Court, that falls under a constitutional question. We take it for granted now, but it's fairly novel at the time that this opinion is written. So these three questions, you should have seen them. Probably the most well-ordered part of the case. Once you get into it, the court will kind of give itself a agenda, a syllabus to go over, and kind of figure out what sort of questions it needs to resolve, right? What sort of questions it's going to ask. So the first question is whether Mr. Marbury even has a right, does he even have a right to obtain his commission. That's the first question there. The second question is whether there's a remedy, right? Whether there's a way to redress the possible wrong that was committed. And then finally, what are we going to do about it, right? What kind of resolution can the court provide? It's one thing that the Mr. Marbury wants to petition the Supreme Court to issue a writ of mandamus to say, hey, wait a second, guys, I had this right to become the justice of the peace. I had my former president sign off on everything, but now there's been a change in office, so hey, my right's been infringed. I have a right to be appointed into this position. My remedy would be basically to have those papers delivered to me, or have that commission delivered to me, or be able to actually be instated into the office. So then what's the resolution? So it's one thing to have a right, it's another thing to have a remedy, but finally, what can the court actually do about it? How can it resolve this dispute? So, our characters here: William Marbury, James Madison. I'm looking at this from a 10,000 foot view. I probably should have touched on this earlier, but the legal facts of the case are very important until they're not important at all. So it's important to now start teasing out which facts we need with our attorney caps on to think about the analysis and which facts are not. So, for example, Marbury, he was appointed a position as a justice of the peace for, I believe, Washington, D.C. Now, does it matter if it was Washington or Philadelphia or Florida or whatever? No, it does not. The point of the matter is he was supposed to become basically a judge, a justice of the peace over this certain area. Now, how did that become the case? Congress passed a law that allowed the then sitting president, John Adams, I believe, again, a fact that is historically important. Is it legally important? No. To basically appoint more judges, to have more power distributed by means of appointing more people to the bench. Now, we'll see that play out. That's not a foreign concept, at least it shouldn't. If you, as a political leader, can put more of your people in positions of power, the more influence and control you can have while you're in office and certainly after you leave office. So then what happened? James Madison, the new Secretary of the State, wouldn't deliver it, right? Wouldn't hand it over. Different political parties, there might have been personal animosity. Who knows? Who really cares? But who knows? All that we need to know and focus on is that James Madison had what Marbury wanted. Okay, Marbury wanted to sit on the bench. He wanted to be the justice of the peace, but there was this weird final piece of the puzzle to basically get instated into his position. So the court talks about that later on in the case, right? They look at the nomination, the appointment, and the commission. Those three different aspects of this law. So there's the act of the president. That's the nomination. It's completely voluntary. You have the actual appointment. This is also the act of the president. And it's a voluntary act, though it can only be performed by and with the advice and consent of the Senate. So you involve more of the people. Once the president has nominated a given person to sit on the bench or become justice of the peace, then the appointment takes place. Final piece of the puzzle is that commission. And that's really the issue here. So to grant a commission to a person appointed might perhaps be deemed a duty enjoined by the Constitution. He shall, says the instrument, commission all the officers of the United States. So that's kind of where we're at right now. To be very simplistic here, Marbury has been wronged. He wants his commission, and the only person that can deliver it or pass it forward, give it to him, is James Madison, who's basically sitting on it, right? He doesn't necessarily want Mr. Marbury to be a judge. He doesn't want that sort of political power to be distributed across the city or the district or wherever he's going to sit. And so that's a tension, right? That's a tension right now. Marbury doesn't have something, and what he doesn't have, he wants. And what he wants is what James Madison has, but won't give. Okay? Put it into those terms, all of a sudden, it probably looks like several disputes that we've seen, not only in history, but in our own personal lives. So enter the Supreme Court. The Supreme Court then has to sit in between this dispute and basically figure out, now wait a second. One, does Marbury even have a right to this? Is he even entitled to the commission that he says that he wants or that he deserves? And then two, what's the actual remedy, right? What are we going to do about it as far as if he does have a right and that right's violated, what's kind of the answer, right? How do you get over this? And then finally, are we the right people to do that? There's any sort of example could come to mind. Of course, they're all escaping me at this moment. But if you have, siblings, let's say, for example, and I don't know, your sister has the last piece of cheesecake and you really want that cheesecake, right? You're not going to go to your neighbor, right? You're not going to go to your friend and be like, man, will you please make her give me that cheesecake? No, right? You're probably going to appeal to the authority that you think is in control, right? Your mom or your dad, to say, wait a second, let's share here, right? What were the rules? What were the house rules? All that kind of stuff. So in this particular case, that's the issue at hand. Marbury thinks he's entitled to have his commission delivered by James Madison, the Secretary of State, and he is appealing to the court to say, hey, court, tell James Madison to give me my commission. Pretty simple in that regard, but then we have, of course, this whole opinion that makes it less so. Okay, so where are we at now? The court then divides this opinion based on those three, right? The right, the remedy, the resolution. And they first have to ask whether Marbury was appointed to the office and thus entitled to his commission as Justice of the Peace. Short answer is yes, right? They look through that. They look through the entire analysis. It's very difficult to follow, but they tease out the language of the law, the Judiciary Act, to basically figure out, the commission and the appointment are basically inseparable. So they're parsing through the different stages of, again, the nomination, appointment, and commission. And they basically want to know if he was actually appointed to his position. Because if he was actually appointed to his position, then, he has the right. He was already granted that right. And so, of course he does. Why? He was already appointed. So at that point in time, what do we do about it? So the commission has been signed by the president. The appointment was made. The commission is complete when the seal of the United States was affixed by the Secretary of State. So you don't have to actually deliver it, right? There's not a physical delivery, but that seal was affixed. So they look at it and they say, well, yeah, absolutely. His right was violated. He is entitled to be in that position on the bench. And so his right is violated. Got through that first aspect. So now what, right? What kind of remedy is available? And this is where we get into a very important concept of law, very important foundation of law. So starting on, it would be page 163, the way I think I'm going to cut it. It says the very essence of civil liberty certainly consists in the right of every individual to claim the protection of the laws whenever he receives an injury. One of the first duties of government is to afford that protection. So they're quoting a commentator basically on the law, Blackstone, who says it is a general and indisputable rule that where there is a legal right, there is also a legal remedy by suit or action at law whenever that right is invaded. Jumping down a little bit further, that all possible injuries whatsoever that did not fall within the exclusive cognizance of either the ecclesiastical, right, the church, military, or maritime tribunals are for that very reason within the cognizance of the common law courts. The common law courts of justice. For it is a settled and invariable principle in the laws of England that every right, when withheld, must have a remedy, and every injury its proper redress. Crucial point here that the court somewhat parks on for a while, but for our purposes here, it's worth us thinking about it a little bit further. We know there's a right established. Marbury was entitled to be in that position, in that judicial position, right? That's Justice of the Peace. They parsed through and they teased out the language of the law itself to figure out, okay, there's the nomination that the president had, and then there's the appointment, and then there's the actual commission. But all that happened, and so, right, he should be up on the bench. He should be in that position of power, executing the authority that was given to him, right? That went through all the right steps. And so, yeah, he has the right. And the fact that he cannot exercise that power, that right that was given to him, means that there was a violation of that right. Okay, fair enough. But does that necessarily mean that there's a remedy? Well, no, right? No, it doesn't necessarily mean that there's a way to fix it, okay? So you're driving down the road and someone swerves over and cuts you off. It doesn't hit your car, doesn't cause you any damage, just swerves over and cuts you off. Well, I was driving here, right? I was driving here, bud. Like, what are you doing, man? Like, I was just doing my own business, and all of a sudden you cut in. So we may say that, oh, okay, you had a right to drive there or whatever, but then someone infringed on that right. Is there any kind of remedy for it, though? No. There's no damages, which we'll get to later on as well. And really, more importantly, is just, okay, it kind of ticked you off, right? It kind of upsets you. It puts you maybe in a sour mood for a bit. Is it worth getting the courts involved, though? Is it worth any kind of remedy at law? No, probably not. Well, that's where we start looking at what, in fact, is a legal right. A legal right that's granted from law, right? So not a God-given right, but that law provides. We would say that it's the very essence, as the court says, of civil liberty, to protect those rights given by law. So, the injury is very important, the damages aspect, but then it's also a general and indisputable rule that when there is a legal right, there's also a legal remedy by suit or action of law, whenever that right is invaded. So the court's looking at this, and they're thinking, okay, we know there's a right. We got that in the first section. Now what? We got to figure out if there's a remedy. Well, operating on, again, a foundational or principle of law, I'm okay with that. Anytime you have a right, there's got to be a remedy. So if it's not within the confines of the church, military, maritime tribunals, right? They deal with their own stuff, is basically what the court or that commentator is looking at. Then it's got to go to common law. It's got to go to common law course of law. And so the court is okay with that. You know, they are basically saying, here is a right that Marbury had. It was infringed upon. There's no other way to redress this issue or fix this wrong. So we're going to go and look into it, right? We're basically going to look and try to find a remedy, knowing that it's a foundational aspect of law. So the remedy, though, gets tricky. It gets tricky here because now we're looking at making this James Madison guy over here give that commission and state Marbury into this position. And so that's the remedy, right? That would fix the wrong. That would get what Marbury was asking for. But how, right? How does that work? There's a good analogy here, I think. Let's see, 165, talking about land patents. And so it discusses that, basically someone back in the day could go and pay the government for the government to grant them land. That's how you had these huge homesteads or other things of that variety. Patents are what they're called, where the government itself gives the private citizen the land. So they asked that question: if the Secretary of State should choose to withhold this patent, or the patent being lost should refuse a copy of it, can it be imagined that the law furnishes to the injured person no remedy? It follows then that the question whether the legality of an act of the head of a department be examinable in a court of justice or not must always depend on the nature of the act. If some acts be examinable and others not, there must be some rule of law to guide the court in the exercise of its jurisdiction. So we're kind of in this weird situation all of a sudden. I think it's important to understand the historical context, but the court is positioning themselves as best they can as a third party, as a neutral party. So if you have this aspect to use their land patent analogy, where the private citizen has paid the Secretary of State, right? Followed the law, did everything that was required of him. That I think, let's see, an act passed in 1796. It says, using that example. So the citizen followed all those aspects of law. So then, what happens if that Secretary of State doesn't actually deliver that land patent, basically a deed? If the government doesn't deliver that deed, that patent to the private citizen, or won't even make a copy if the patent's lost, well, yeah, we would say that that's an injury, right? The citizen had the right to receive that land patent, that deed, that land itself, title to the land, I should say. So if the citizen follows all those steps and does all the right requirements that the law provides, again, that act passed in 1796, then it would follow that if it doesn't happen, if the Secretary of State does not deliver the patent, then there's an injury. There has to be a remedy. Using that analogy, we can see it's the same principle here. Marbury had a right. All the process went through with the presidential nomination, the Senate confirmation, an appointment, and then the commission with the affixed seal by the Secretary of State. And so now we're at the point of, hey, Mr. Madison, time to give it up, man. Like, it's time to go ahead and instate Marbury into his position that you are required to do based on this Judiciary Act. Okay, so we have the right. There is, in fact, a remedy that would fix that wronged Marbury. Let's jump down to right before 167. That where the heads of departments are the political or confidential agents of the executive, merely to execute the will of the president, or rather to act in cases in which the executive possesses a constitutional or legal discretion, nothing can be more perfectly clear that their acts are only politically examinable. But where specific duty is assigned by law and individual rights depend upon the performance of that duty, it seems equally clear that the individual who considers himself injured, Marbury, has a right to resort to the laws of his country for a remedy. Everything's going good for Mr. Marbury. The court is just following right along, hearing his sad song. You get the violin in the background. He's got the tears rolling down. It just seems like, well, yeah, okay, you had a right to this. Mr. Madison's infringing on that right. So, yeah, you're appealing to the laws of your country to address that wrong. Everything's going good. So he concludes. I really appreciate when courts do this, as well as kind of a nice little summary. This is 167 to 168. So it is then the opinion of the court. So this is where we are so far in the case. We've gone through the first 2 points, the right and remedy. So it says, it is then the opinion of the court that by signing commission of Mr. Marbury, the President of the United States appointed him a justice of the peace for the county of Washington and the District of Columbia, and that the seal of the United States affixed thereto by the Secretary of State is conclusive testimony of the verity, of the signature and of the completion of the appointment, and that the appointment conferred on him a legal right to the office for the span of first years. He's got a legal right. Check. Now moving on to remedy. Let's see. So, opinion of the court that, having this legal title to the office, he has a consequent right to the commission, a refusal to deliver, which is a plain violation of that right, for which the laws of his country afford him a remedy. Awesome, right? We're doing great. This will be those times if you're an attorney representing Mr. Marbury, you're like, wow, the court is just seeing what we're seeing. We're doing great here. Love the way this is going. So now the question remains, is he entitled to the remedy for which he applied? So he applied for what's called a writ of mandamus. Basically, the court, he's asking the court to tell Madison to hand it over, right? To give him that commission. Make him do it. In law, we still have those. It's basically, when it gets to a pretty serious matter, we do not use them flippantly. when we petition the court to say, make someone do something else. There's a variety of writs. We may get in that later, but for our purposes here, a writ of mandamus, which I think there's a good quote. Yeah, is basically saying, go do this thing. So, start of 169. No other specific legal remedy. This court, actually, let me back up. So we're in a case from England, case of King v. Baker. Whenever, says the very able judge, there is a right to execute an office, perform a service, or exercise a franchise, more especially if it be in a matter of public concern or attended with profit, and a person is kept out of possession or dispossessed of such a right, and, it's very important, no other specific legal remedy, this court ought to exist by mandamus, upon reasons of justice, as the writ expresses, and upon reasons of public policy, to preserve peace, order, and good government. This writ ought to be used upon all occasions when the law has established no specific remedy, and where in justice and good government there ought to be one. Everything's hopefully making sense at this point. Marbury has a right. He should be in office. He should hold that office of justice of the peace. That right was conferred to him. There is, in fact, remedies available that he has availed himself to the laws of the United States to make right the wrong that was committed to him. So, what now? Well, in his mind, or his attorney's mind at least, they petition the court to say, hey, court, oh, Supreme Court of the United States of America, tell this guy to give me my stuff. Give me my right. Make him do it. Court's looking at this and like, you know what? Yeah, we know there's a right that was wronged. We know there's a remedy. We're not sure really which one. So are we the right guys to do it? Looking at their existing case law, right, precedent. Let me back up. Not really case law. It's more looking at precedent from a case here that was in England back whenever. When there's no other specific legal right, that's when the writ of mandamus will be effective. So if you have no other avenue to address this wrong, then the writ of mandamus can be issued. Well, that's basically what the court's starting to look at next. They're recognizing that there's really not any kind of specific remedy available for him, that the writ of mandamus may in fact be the only option available to get or to redress the wrong committed to Mr. Marbury. So, let me see what's on this next slide, if it's what I think it is. Yes. So, everything is going smooth, as perhaps as smooth as Mr. Marbury could hope from the court at this point. Now, we're now on 172, 173. It is true that the mandamus now moved for is not for the performance of an act expressly enjoined by the statute. The statute doesn't provide for it. There's no kind of contemplation of, well, what if the Secretary of State doesn't hand it over, right? Doesn't instate the nominated, appointed, and commissioned guy to the bench. What then? So the court says it is to deliver a commission on which subject the acts of Congress are silent. It has already been stated that the applicant has, to that commission, a vested legal right, of which the executive cannot deprive him. He has been appointed to an office from which he is not removable at the will of the executive, and being so appointed, he has a right to the commission, which the Secretary has received from the President for his use. The act of Congress does not indeed order the Secretary of State to send it to him, but it is placed in his hands for the person entitled to it, and cannot be more lawfully withheld by him than by any other person. This, then, is a plain case for a mandamus, either to deliver the commission or a copy of it from the record, and it only remains to be inquired whether it can issue from the court. So this is fantastic news, okay? There is a right. It was infringed upon. There is no other legal remedy, therefore mandamus is proper. Oh, but is it proper from this court? Okay, So now we're getting back to original and appellate jurisdiction. This part of the case gets pretty heady, so I'm going to go zoom back out to 10,000 feet and look at it. The court is now reconciling whether it is the proper entity to deliver that writ of mandamus, to tell this other guy, to tell Mr. Madison, hey guy, go do this thing. We know that the writ of mandamus is proper, but the question now is whether the court has jurisdiction, has the power to, in fact, issue that writ of mandamus, to tell Mr. Madison what to do. Okay? Court gets into original and appellate jurisdiction again. They look to Section 2 of Article 3 to figure out what their powers, in fact, are. Where are those limits there? There's a great quote in there that we are a country of laws, not of men. And so the court is looking at their limited power. They're saying, look, the Constitution gave us certain limited powers within our scope of jurisdiction. And notably, the issuing writs of mandamus come from appellate jurisdiction, not original jurisdiction. Okay, so if it is coming from appellate jurisdiction, then sure, we could issue that writ of mandamus. But because it came from the original jurisdiction, the court cannot. The court cannot go and issue that writ of mandamus, cannot tell Mr. Madison what to do. Why? Because it would violate the Constitution. Tremendous point here. The reasoning, I think, is sound, but may require a little bit deeper dive when we get to the discussion questions to really hone in on this. So it's really the last couple pages of the case that are crucial for our time. I'm going to kind of read through this and let the court speak for itself. So we're at, let's see, where are we? 176. The powers of the legislature are defined and limited, and that those limits may not be mistaken or forgotten. The Constitution is written. Very important. To what purpose are powers limited, and to what purpose is that limitation committed to writing if these limits may, at any time, be passed by those intended to be restrained? It is a proposition too plain to be contested that the Constitution controls any legislative act repugnant to it, or that the legislature may alter the Constitution by an ordinary act. In other words, the Constitution is more important than any of the laws that are passed. Why? We have to have the third thing. We have to have something else to appeal to. If it's just another body of legislation that can be flippantly changed on any given whim, then how are we going to have anything stable, right? How are we going to maintain any sort of limits? It's going to ebb and flow, back and forth, up and down. We don't want that as a society, as a civil government. We want consistency throughout the generations and the decades for our country's life. We have limited powers granted through the Constitution to our bodies of government. And so we write that down, and if it is nothing more than just another piece of legislation, then what's the point? What's the point? Going back to the court. Nice colorful commentary there. I get fired up about these things. The Constitution is either a superior, paramount law, unchangeable by ordinary means, or it is on a level with ordinary legislative acts. Like other acts, it is alterable when the legislature shall please to alter it. The court says there is no middle ground, right? It's either the supreme law of the land, or it's just another piece of legislation that can be changed at any given point in time when the next politicians get into office. Jumping down a little bit further. If an act of the legislature repugnant to the Constitution is void, does it, notwithstanding its invalidity, bind the courts and oblige them to give it effect? Or, in other words, though it be not law, does it constitute a rule as operative as if it was a law? This is the quote from Marbury v. Madison. it is emphatically the province and duty of the judicial department to say what the law is. Those who apply the rule to particular cases must of necessity expound and interpret that rule. If two laws conflict with each other, the courts must decide on the operation of each. So, if a law be in opposition to the Constitution, if both the law and the Constitution apply to a particular case, so that the court must either decide that the case conformably to the law, disregarding the Constitution, or if conformably to the Constitution, disregarding the law, the court must determine which of these conflicting rules governs the case. This is of the very essence of judicial duty. If, then, the courts are to regard the Constitution, and the Constitution is superior to any ordinary act of the legislature, the Constitution, and not such ordinary act, must govern the case to which they both apply. So, a lot of words, super important concept. I mean, that just took off through all of jurisprudence. American jurisprudence is arguably founded on this concept right here. So, several things. First of all, the judicial department, the Supreme Court, is going to say what the law is. So, in other words, they're not going to make the law, legislative branch, and they're not going to enforce the law, executive branch. They are tasked with saying what the law is. Now, here's the important jump. Let's see if I have my nice little illustration over here. Worked out better than I thought. Congress promulgated the Judiciary Act of 1789. That's what caused basically this whole dispute, is that it broadened the powers for the president to appoint more judges, essentially. Now, what the court is looking at initially was whether and how to enforce that act. What Justice Marshall does here, though, is say, wait a second. Our job is emphatically to say what the law is. We're not here to think about what the law could be or should be, or what it needs to be, or how to enforce this, or if Congress left something out, we're going to fill in the blanks. Not going to do it. Nope. The court, the Supreme Court, and by implication inferior courts as well, but the Supreme Court is going to determine and say what the law is. So, how do they do that? Well, if a law is passed such that it runs afoul of the Constitution wins. Okay? The Constitution is going to be the supreme law of the land. So if a law be in opposition to the Constitution, then the Constitution wins out. It's going to determine what the law is. That is our third thing, right? Our tertium quid. We're going to appeal to the Constitution to figure out whether a given law is constitutional or legal or can be applied or whatever else may be. And so this is the concept of judicial review. Again, not in the Constitution. But the court in Marbury v. Madison said, we're going to tell you what the law is. And if any given body of law runs afoul of the Constitution wins every single time. It is the supreme law of the land. This final quote here. The judicial power of the United States is extended to all cases arising under the Constitution. So any time now there is any sort of issue of constitutionality, of disputes involving different entities, but federal law kind of in general here, the Supreme Court has final say. It gets to decide what it's going to do because they are the ones tasked with saying what the law is, And they've said now the Constitution is the supreme law. And so now anything that falls within the purview of the Constitution belongs to the Supreme Court. Just like that. I mean, we're talking about a couple pages here, if that. But a super important concept. I would argue that it makes sense. We'll kind of touch on this in the... check my notes real quick. We'll touch on this in the discussion questions of reconciling that reasoning. But I hope that it is making sense. I think, like I said from the jump, we take that for granted, that the Supreme Court can, in fact, really state the law in the first place. That's just like a super foundational, fundamental concept. But wow, that's where it came from. Okay. And then the fact that it can review law to determine whether it comports with the Constitution. Again, I love this illustration, so I'm gonna use it again. But if Congress passes a law, whatever it may be, and it's ultimately challenged, and it could be a state for that matter too, but if it's challenged by someone saying that it violates the Constitution, the Supreme Court, and really any inferior court, again, the circuit courts, the district court, whatever it may be, has the power now to say whether it's constitutional. So this final question here, so to leave you with, how can the Supreme Court determine the legality of a given dispute without first considering the Constitution itself? That's the whole idea. That's our tertium quid, right? That's our third thing here. We're going to appeal to a third standard. So not just the two disputing parties, not just Marbury v. Madison, who is right, who's wrong, but we're actually going to look at the Constitution to figure out what we're going to do about a given dispute. So in summary, we have Marbury is in fact entitled to his commission. He had the right. It was a vested legal right. Madison wouldn't give him over to him, wouldn't appoint him, or wouldn't deliver the commission, or wouldn't fulfill his end of the bargain, whatever it may be, that he didn't do that he needed to do. And so the court's going to be like, yep, there is a right, and now there's a remedy, but the law doesn't provide for a remedy. There's no specific remedy, so yet writ of mandamus is in fact correct. It's correct avenue to pursue. Ooh, we're not the right court to do that. Why? We are only here to say what the law is. The Constitution is going to be the supreme law of the land. So even though this other law, the Judiciary Act, does not provide for a certain remedy in this given scenario, our task is limited to issuing writs within appellate jurisdiction. We don't have appellate jurisdiction in this case. We have original jurisdiction. Therefore, we're going to follow the Constitution at the expense of giving Mr. Marbury his requested remedy, issuing the writ of mandamus, because reviewing and following the Constitution is in fact the most important thing the Supreme Court can do. So, very important concept. I hope there's questions. Please email me. Happy to discuss further. This was a very, what word do I want to throw there? Tough, convoluted. Ooh, I like that one. Convoluted case to read through. If you do go to law school, it's hopefully one of the first cases you read. So it just takes practice. So again, when you're reading the case, think about what is that dilemma, right? What is that issue? What are they appealing to? What is that rule? And then we'll look at the analysis more and more and more to ultimately decide what the conclusion is going to be. So any questions, please let me know. Email me. Happy to walk through any sort of additional information too. And then you'll have your writing assignment, your weekly assignment as well. That'll hopefully give you a chance to kind of dig out these details a little bit more. But in the meantime, pray that this blesses you. You have a blessed week, and I'll see you next time.